All rise. Court of Appeal in the Fifth District of the State of Florida is now in session. The Honorable Carrie I. Evander, Chief Judge, presiding. All persons having business before the court draw near, give attention, and you will be heard. May God save the United States of America, the State of Florida, and this honorable court. Please be seated.
Okay, good morning, and welcome to a session of oral arguments at the Fifth District Court of Appeal. I've already been introduced. Let me go ahead and introduce the other panel members. To my right and your left is Judge Richard Orfinger, and to my left and your right is Judge Rand Wallace. We have 3 cases scheduled for oral argument today. In each of the cases, each side will be entitled to 20 minutes total. The appellant will be entitled to divide that time between an opening argument and a rebuttal argument. If appellant's counsel will let me know how much time you wish to save for rebuttal, I'll try to help you in that regard. Also, if you have any electronic devices, cell phones, anything like that, make sure they're turned in off or in the silent mode. After the second case, we'll take a recess, and any attorneys who wish to join us in the attorney's lounge, we'd be glad to meet with you and talk about any matter other than the case that you argued. So at this time, we'll go ahead and start with the case of Lanford versus PHEMISTER.
Good morning. Hope I don't lose my voice already this morning. May it please the court, my name is Bob Wilkins. I'm here representing the appellant, Scott Lanford. I'm going to be pretty brief in my argument today, but I want to focus on...
How much time do you wish to reserve for rebuttal?
10 minutes, Your Honor. Okay. I will be very brief in my initial argument, but I want to focus on a couple of important points. The first point I want to make is that there was apparently the overarching concern seemed to be the existence of an advisory fee agreement between B.J. Shell and Retirement Services of America, under which Mr. Lanford would receive a finder's fee or a part of that advisory fee. The problem with the ruling of this court, or the ruling of the lower court with respect to that issue, is that there was no advisory fee agreement in existence. 8 months before Mr. Lanford was removed as trustee of the Testamentary Trust, as set up by Mrs. Dillard, that agreement was rescinded. So we had no agreement at the time that he was removed, and in fact, there was, if you look at the arguments that were made by the appellees below, their argument was that there was some agreement that was going to run into perpetuity, so Mr. Lanford would receive 1% referral fee for the rest of his life or into perpetuity. Well, first of all, that's just flat not true. Number one, the agreement was with B.J. Shell, and B.J. Shell is now deceased, so that agreement would have terminated on its own anyway. Number two... I thought
the agreement was with some company, Retirement Services
Correct.
Incorporated or something like that.
Correct. It was Retirement Services Incorporated and B.J. Shell. They were the parties to that agreement.
No. It was the corporation that was the party. I mean, I've seen the agreement. I've got it right here. It says it's an agreement between Retirement Services of America and Miss Shell.
Correct.
Or no, not Miss Shell, but... yeah, Ms. Shell.
Yeah, that's exactly right. But the issue with respect to Mr. Lanford is that he received a 40% fee of that advisory fee from Retirement Services of America. That's the issue that I think they've been raising as being the conflict or the adverse interest. Well, and again, at the time...
Doesn't that create a conflict? I mean, up at the time he entered into the agreement, he meaning your client, with the advisory fee, didn't that create a conflict given the way the very odd way the trust was drafted in this case?
A conflict with whom, Your Honor? with my client and whom? Ms. Shell?
Well, I'm not sure, because they didn't designate any beneficiary after Ms. Shell died who would ever be able to enforce the agreement, because A, it really would last forever because they were only distributing the minimum, and B, they could give it to whatever charity they wanted, so that nobody was really in a position to ask any questions.
Well, first of all, we're not talking about his removal as trustee of the Kirk Foundation. The Kirk Foundation is not at issue before this court. There is no fee agreement, no advisory fee agreement with the Kirk Foundation either. In fact, if Your Honor wishes to review it, that agreement was essentially off of the IRS website. That's exactly the form agreement that the IRS gives you for these types of charitable remainder trusts. And the requirements of the 501c3 organizations would have required them to only charge reasonable fees. This agreement is not part of the Kirk Foundation. The Kirk Foundation would be governed by its own rules with respect to payment of trustee fees, payment of advisory fees, et cetera. So I don't think that creates a conflict. The question is, was Mr. Lanford in conflict with B.J. Shell?
Well,
that's what he was removed for. He was supposedly in conflict with B.J. Shell. That was the beneficiary under the Testamentary Trust. That's where the focus is.
The advisory opinion from the Ethics Committee requires several things, but it requires the lawyer to make full disclosure and obtain the informed consent of the client in writing, and the client receives the benefit of the referral fee.
That's correct.
So how was that done? First of all, how did the lawyer here, not retirement services of whoever, but how did the lawyer make a full disclosure and obtain the informed consent of the client in writing? And how did this benefit the client?
The informed consent agreement is in the record.
No, that agreement is between retirement services and
That's
Ms.
correct.
Shell.
There is a separate disclosure that's in the record, and I can perhaps give Your Honor that.
I've got it. It's page 879.
Is that that's the agreement that discloses the advisory referral fee?
Right, Appendix C.
And so the disclosure was made to B.J. Shell. How is it in the best interest of B.J. Shell? Well, I think as Mr. Lanford testified in his deposition, basically she no longer has any trustee or attorney's fees or accounting fees for the rest of her life. That's the benefit to her. She pays an advisory fee that is not that unreasonable for management services, and then Mr. Lanford serves as trustee if she becomes incapacitated. He serves as her attorney, and he essentially, part of the agreement is that her tax returns are prepared and filed on her behalf. So the benefit to her is it's going to save her money in the long run. There isn't a trustee fee. In fact, it's unfortunate we don't have the full record from below, but Regions Bank served as trustee for this trust. The fees they have charged exceed that 2.5% fee.
Is that in the record?
It's not in the record, so we want to address it. But the point is, this court cannot objectively view or evaluate that agreement and the compensation of that agreement in the abstract. You'd have to have something to compare it to. And in this case, what happened was B.J. Shell got substantial benefits because had Mr. Lanford been allowed to serve as her trustee going forward, he would have only gotten a 1% of the asset fee annually, which would have been all that was ever paid, would ever be paid by B.J. Shell or her guardianship for trustee services.
Well, so, as a matter, because there's no one to enforce the agreement the way, or the trust agreement the way it was structured, as a practical matter, RSA or whatever it's called could put the money in the bank and do nothing, and Mr. Lanford would get 1% of $3 to $4.5 million a year, and the advisor would get 1.5%, and there would be no one there to say you're doing a lousy job of investing the money, correct?
Not true. If B.J. Shell had been competent, which she was for a period of time.
Well, I'm talking about after she died.
After the agreement terminates after she dies. There's no agreement, there's no party to the agreement after B.J. Shell dies. You can't have an agreement that survives forever. In fact, if you'll notice, the agreement can be terminated by either party at any time. And that's exactly what happened. Mr. Ruggiero, on behalf of Retirement Services of America, terminated that agreement. There was no agreement.
What about the Kirk Family Trust then? That was a separate agreement, correct?
There was no agreement with the Kirk Trust. There was no advisory services agreement with the Kirk Trust, period. That does not exist, never has existed.
But are we supposed to just put on blinders and not look at the issues related to the Kirk Trust as we look at this problem?
Well, Your Honor, if they were asking the court to remove him as trustee of the Kirk Trust, that's a different issue. What they removed him from is a testamentary trust for B.J. Shell. That's what we're here on. That's what the removal was. And ultimately...
Did the court's order actually reference removal as the trustee? I don't believe it did, correct?
Well, what else did they do? It has to be removal because the trustee was ready, willing, and able to serve, had filed their homestead petition.
The motion the court was considering was the appointment of the trustee, correct?
No.
That was what was noticed for hearing.
No, what they said in their motion is that they wanted the court to determine who the trustee should be. Here's what their motion said. It's paragraph 9. It says, the adverse interest and potential conflict of interest determined to exist in this estate administration also exists in the administration of the trust for the benefit of Billy Joe Shell, not the Kirk Foundation, for Billy Joe Shell. And then they say, determine the appropriate trustee for the benefit of Billy Joe Shell. The trustee is named in the will. The trustee is Scott Lanford.
When was the will filed subsequent to the death of the Miss Shell?
I think it was about 7 months afterwards, Your Honor.
And how did, I mean, does that demonstrate diligence?
It does not. It does not. I can't explain, and there's no evidence in the record as to why that delay. There was some testimony about Mr. Lanford waiting for the niece of the decedent to help clear out the house of the personal effects and things of that nature. But frankly, there is no excuse for not filing that will. Opening probate, different question, but there wasn't any excuse.
Right.
But
the trust would be funded after the will was administered.
Correct. And that's when Scott Lanford would have become the trustee. And
but because of his delay in filing the will, the administration of the trust was delayed for at least 7 months, correct?
The administration of the trust would have been delayed for at least 7 months.
Because of his actions.
If probate is supposed to be completed within a year, they didn't complete it within a year.
Well, when's the will supposed to be filed?
10 days after notice.
And here was 7 months.
It was.
And so that period of time, the trust was not funded as it should have been. And the beneficiary did not theoretically have, could have received benefits from a funded trust, but didn't happen because the will wasn't filed.
Well, keep in mind, and again, the inventory is in the record here. The Dillard estate is very modest. There's only about $15,000 worth of assets, $5,000 worth of claims, and a homestead property. That's it. That's all that's in this estate.
Does a beneficiary have the same rights, whether they're a beneficiary on a $3 million trust or whether it's a $100,000 trust?
No. I mean, yeah, they do have the same rights, of course. And again, the delay issue, I think, is a complete red herring because that has nothing to do with the administration of the trust.
Or would it support a finding that Mr. Lanford had not accepted the responsibilities of being trustee when he's the one that delayed the funding of the trust?
Well, Your Honor, if you look at the reason he was removed and denied appointment as PR, it was because of conflicts, not because of delay. The court never said, I'm removing him because he filed the will 7 months late.
Did the court say removed?
I'm sorry?
Did the court use the word removed?
It denied his appointment as PR. And he was already trustee. He had already filed a petition as trustee. He had already accepted the responsibilities of being trustee. Those facts are in the record. You'll see the homestead petition was filed by me on behalf of Mr. Lanford as trustee of that trust. So that's all. There were no other assets distributed at that point. In fact, there will probably be no other assets from the estate going into that trust because the estate's going to be insolvent at this point.
All right, you're a little over 7 minutes, so I don't know if you want to.
That's fine. Thank you, Judge.
Okay.
May it please the Court. My name is Scott Krasny. I represent Robin PHEMISTER, who's the personal representative of the estate of Mary Dillard, and also the appointed trustee of the Testamentary Trust established under her last will and testament. And Your Honors seem to be very familiar with the issues related to this case. The question really is whether the trial court erred in appointing my client as the trustee of that Testamentary Trust, and our position is the court did not make a mistake in that regard. There's really 4 cases that are combined in this issue. The first is the Mary Dillard estate and the action and inaction of Mr. Lanford, an attorney licensed to practice the law. The attorney who drafted the will, he and his wife were witnesses to that will, creating an estate plan also for Mary Dillard's sister, B.J. Schell. And B.J. Schell was the beneficiary of the trust established for Mary Dillard. But it's really those B.J. Schell trust documents, because Mr. Wilkins is exactly right. That was where all the money was. The money was in the estate of B.J. Schell. And so looking at those 2 together, because already before Mary Dillard died, there were already a couple of cases that had already been kicked off. The first was Regions Bank filing a deck action that said, hey, Mr. Lanford is asking for all this B.J. Schell money, and we don't think we should turn it over. And that lawsuit was filed like at the end of 2015. That case was proceeding. Mr. Lanford then filed on behalf of Mary Dillard a petition to have B.J. Schell declared incapacitated. That case was then dismissed and refiled with a different petitioner, but Mr. Lanford's fingerprints were all over that, trying to have B.J. Schell declared incapacitated. And then he testified, and I point out the record in the brief, where his testimony, he was being pursued because he was also a power of attorney, and evidently the state attorney's office was involved in the issues related to B.J.'s assets, and his power of attorney was revoked. And he testified about why it was revoked. Based upon the advice of his counsel and the Laura Moody, who worked with the state attorney's office, they suggested that he revoke the power of attorney, and he went over to her house, and he did. He revoked it. So the guardianship proceeding gets started. There's all these issues related to B.J. Schell and the estate planning documents that Mr. Lanford prepared for B.J. Schell. And ultimately, in a very contested guardianship case, Judge Davidson ruled, and appropriately ruled, that my client, a professional guardian, my client's a professional guardian, she should be appointed as the plenary guardian for B.J. Schell. And that order appointing her was on 4/6/2017. Now, Mary Dillard had died back in October of 2016. It would have been an easy enough thing to start that estate, and Judge Evander, you're exactly right. What should have immediately happened is Mary Dillard's estate should have been open. A notice for creditors should have been run. He should have filed that original will. He should have done all of the things that you would normally expect someone to do if they're appointed as a fiduciary in a will that they draft. But he did none of it. He didn't file the original will. Matter of fact, when I took his deposition, and I've included the deposition in my brief, and I said, why haven't you started? Well, and this was 4 months after she was dead. Why didn't you do something? Why didn't you file? Well, you know, she's clearing out tangible personal property. Now, Judge Evander, and I'm not familiar with other judges in terms of your issues related to probate law, but in terms of real estate vests in the people that are getting it as the moment of death. He could have immediately taken action with respect to the testamentary trust and the real property that was titled in Mary Dillard's name. But he did nothing. And so the house started falling apart. So when the professional guardian got appointed, we immediately filed a petition for administration on May 2nd. Less than a month later, we filed a petition to be appointed, indicating that we thought there was an intestate estate, because why wouldn't somebody file the original will, especially the attorney who drafted it? And immediately, and again, there was one other thing that's going on. In that deck action, once the guardian was appointed, Judge Turner ordered a consolidation of all of those actions into the probate court. So all the issues related to B.J. Shell's estate planning documents were now in front of the probate court. That order on consolidation was on May 12, 2017. It was only then, on May 15, 2017, that they filed their petition for administration indicating, oh, by the way, here's the will. And they filed the will like 2 or 3 days after they filed their petition for administration. And it begs the question, why? Why? Because there's a lot more money over in B.J. Shell stuff, and fighting about that B.J. Shell's guardianship of estate's more important than it faithfully and dutifully administering the estate of Mary Dillard. The court rightfully ruled that Mr. Lanford should not be appointed as personal representative, and that order has not been appealed, indicating that Mr. Lanford had an interest adverse and contrary to the administration of the estate, an interest adverse to B.J. Shell. Now let's take a moment to look at what his estate planning for B.J. Shell consisted of. A revocable trust, powers of attorney, which were then revoked. This trust that then dumps into the Kirk Family Foundation, a foundation created by Mr. Lanford, witnessed, I believe, by Mr. Lanford and Mr. Ruggiero, and Mr. Ruggiero was also witnesses to other documents. Mr. Ruggiero was the investment advisor who was going to get this 2.5% referral fee or asset management fee. And I would argue that anybody that's paying 2.5% for investment management fees is getting ripped off anyway. But then for the attorney to get 40% of that investment advisory fee as their fee for legal services, that is patently unreasonable, and it violates all of those ethics opinions that we talked about. I don't think any attorney could think that it's appropriate for them to receive 1% of their client's wealth, especially in perpetuity. The way he drafted these documents, this charitable trust would never, there's no qualified beneficiaries that would ever have the right to look at it or challenge it or look at what fees. And when he says, well, that agreement would have terminated when she was dead, that was the footprint, that is the blueprint, that is his business model. And he unabashedly says, that's my business model. Clients come in and I would prepare a will for, this is his testimony, in the Mary Dillard, in the B.J. Shell guardianship. He says, when a client comes in, I'll prepare a will for $595 or $600, but if they've got more than $350,000 of investable assets, if they go to my guy, they never pay me. He gets the 40% of the investment advisor. So let's just take the $350,000 client with investable assets, the little old lady that walks into the office, that's got $350,000, and nobody likes to pay lawyers' fees, right? And so what they say is, well, that sounds like such a great idea. You don't pay me, they pay me. How great. And they sign this one little page document that indicates that Mr. Lanford gets a 40% referral fee, and he makes $3,500 a year for as long as that money's parked there. How? $3,500 rather than a $600 attorney bill. And I think there are ethics opinions that talk about these referral fees, that they're fraught with peril. And it's certainly when you're the fiduciary preparing the estate planning documents and doing the estate planning for somebody, I don't know how you can look somebody in the face and say, you can pay me $595 or you can pay me 1% of your assets, at least as long as you're with my investment guy. And it is.
Was there a services agreement with regard to the Kirk Family Foundation as well?
To my knowledge, that foundation, up until recently, it was never funded because the litigation related to B.J. Shell's case was still ongoing. And so my client was appointed as the guardian of the property for B.J. Shell, and we challenged, we wanted that agreement to be revoked. We didn't want that agreement to be around. And like the day or two before that hearing was done, Mr. Ruggiero sent over a letter saying we're revoking the agreement. I said, I want a court order. And so the Kirk Family Foundation, I think it had never been funded because there was the litigation, and especially at the time that the judge entered the order, all that litigation was still going on.
Who's the trustee of the Kirk Family Trust?
The Kirk Family Foundation, Mr. Lanford.
Mm-hmm. And who are the named beneficiaries?
There are no named beneficiaries. It says that they can make distributions to, and then there was a gentleman, Brian Overby, who formerly worked for Regions Bank, who was named as the trust advisor who could pick charities, and his testimony, which I believe is in the record, says that's not what B.J. Shell wanted. She didn't want the weight. She didn't want to set up a trust in perpetuity. She wanted charities to benefit now. In other words, when she was dead, it should go to benefit charities now. The only people that really benefited from the Kirk Family Foundation are the investment advisor and Mr. Lanford. Why? Because the charitable trust, by its terms, say 5% get paid out to charity. But meanwhile, under the way that the way this business plan was going to function, the investment advisor and Mr. Lanford would have spent 2.5%. And I find that very disturbing. And I really don't understand how in a time when lawyers get bashed for everything that we do anyway, that this can be an appropriate business model. That somebody could walk in and say, look, I'm going to take one. It might have worked for John Rockefeller. He said, I'd rather have 1% of 100 men's labors than 100% of my own. But I don't think that's appropriate, necessary for attorneys when they're referring stuff to their investment advisor. And it is his investment advisor. He testified that Mr. Ruggiero handles his money, handles his wife's money, handles his children's money. Why would you not want to refer your money, your clients, to that person if you're getting 1% of those wages back, one of those commissions back? So all of that was before the court, when the court determined that Mr. Lanford had not accepted or done anything in his role as trustee of that testamentary trust. Not only had he not been appointed as personal representative, but when my client was appointed personal representative, ran notice to creditors, did everything that we were supposed to do, we filed that petition to appoint a trustee of the testamentary trust because Mr. Lanford had done nothing. It was only then that Mr. Lanford filed a petition to determine homestead status, but meanwhile, we had been taking care of the house because Mr. Lanford didn't do anything. It was only then when we said, hey, matter of fact, he didn't file an acceptance of trustee until a couple days after the judge entered the order appointing my client as trustee. And it was certainly within the province of the probate court, who's got a will in front of them with a vacancy because of inaction of the designated personal representative and the designated trustee of a testamentary trust, to appoint somebody in that vacancy. And that's exactly what happened. I mean, they want to talk about removal. They want to talk about due process. There's none of it. I don't see any of it. I see an attorney who's done drafting for the sister, the very wealthy sister of a decedent. The decedent died, creates a testamentary trust for that decedent. There's clearly more money it's worth more fighting over there. And that's one other thing I want to raise. And Judge Evander, you raised the issue perfect. He says it's a modest estate. Then administer it. Do what you're supposed to do. File the will, open a petition for administration, run a notice to creditors, get the house sold if that's what it's going to take. They did nothing. My client did all of it. We did all of it in terms of administering that because they didn't file their petition to determine homestead until March 23rd, 2018. March 23rd of 2018. She died in October 14th, 2016. There is no justification for why, as a designated and nominated trustee of a testamentary trust, under a will that you prepare as the drafting attorney, that you're going to be the one who's going to hold the money and trust as a fiduciary for the benefit of your little incapacitated lady over there, that you're supposedly taking after and looking after her too. But there's litigation over there. And that's where all the money is. So what do you do over here? Nothing. It's a modest estate. It's not worth storing up any other kind of storm. And that's exactly what they did. They did a whole lot of nothing.
Was there any evidence as far as the revenue that was generated by the services agreement for the years of inaction?
Well, at this point, B.J. Shell has passed away, so all of the issues related to B.J. Shell stuff really are not related to this anymore. Once B.J. Shell passed away, my client's role as guardian of the property for B.J. Shell ended. And so that was kind of it. The court appointed an attorney to be the personal representative of B.J. Shell's estate, and that train is out the station. But at least with respect to this estate, and in terms of the administration of this estate and this appeal, the question is there any reasonable basis in front of the trial court for the determinations and the rulings that the court made? And yeah, they hit you like a 2x4. They're right there. his own testimony regarding his conflict with the beneficiary of this testamentary trust, just look at a calendar, his inaction, waiting 7 months to file the will and file a petition administration, and only after we did. Filing the will only after we did and after the cases were consolidated in the probate court. Then waiting another 4 or 5 months until March of 2018 to even file a petition to determine homestead, and only after we did. Why? You'll get no explanation from appellant's brief. You'll get zero explanation as to why that was an appropriate action of a fiduciary, but you don't have to be a rocket scientist to figure it out. When you follow the money was in B.J. Shell's estate. And again, all of this information was before the trial court when the trial court made its determination that Mr. Lanford should not serve as personal representative, not appealed. And again, the interest adverse, the court's ruling that he had an interest adverse, and they talk about Pontrello, they talk about Schleider, they talk about Snyder cases, all of those cases. We fall under all those exceptions as to why Mr. Lanford didn't get appointed, but none of those were appealed. And we flash forward another 4 or 5 months. It only gets worse. Now the case is all consolidated in front of the probate court. We file our petition to sell the house, to get involved, to get the house taken care of. They file their next petition, and then they seem surprised and they want to appeal when the court determines that because of inaction, again, the judge didn't say removal. He didn't file an acceptance until after the judge entered a ruling anyway. Now there's another case, and so we got the Mary Dillard estate, we got the B.J. Shell guardianship, we got the DEC action filed by Regions Bank, and there's another case. The day after my client was appointed as personal representative, Mr. Lanford filed a lawsuit against the estate, filed a claim against the estate in a lawsuit claiming I have expenses and bills. That case is still pending. That case that was in front of the county court, Judge Garagoslo, we had asked it to be consolidated with the probate court. The judge denied our motion to consolidate, but nevertheless, there is still a case where Mr. Lanford has sued the estate, claiming for expenses and bills that he paid out of pocket, including for changing the locks on the house. Well, why? Why? Again, in terms of why would an attorney take those actions and not file the original will and not open up an estate, and then claim there's no conflict or there's no interest or there's no interest adverse when he's a defendant suing the estate, which, as Judge Evander correctly pointed out, pours over into the trust. Everything in the estate that's left in the estate dumps into the trust for the benefit of B.J. Shell. Or, now that B.J. Shell's dead, I guess, back to the Kirk Family Foundation, back now to Mr. Lanford as the trustee of the Kirk Family Foundation, a document that he created that I think Mr. Wilkins just concedes that Mr. Lanford, and I think Mr. Lanford testified. He just pulled it off the IRS website. I've looked for it. I didn't find it on the IRS website, but maybe you'll have better luck finding it than I did. But I don't know anything on the IRS website that says the drafting attorney should be designated as the trustee of a trust that lasts in perpetuity with no qualified beneficiaries. I haven't found that on the IRS website. But that Kirk Family Foundation also says that he's entitled to fees. So despite the fact that he says, I've got an agreement with my client, they never pay fees ever, nothing in the record that supports that. Where is that agreement? Where is that disclosure that's supposed to be into those ethics opinions where you fully set out that conflict that you have with your clients? It doesn't exist. There's questions about B.J. Shell's capacity, and that now that she's dead, that might never be heard. But the question is whether she was competent and understood the nature and effect of what she was doing when she planned her estate, and she came into Mr. Lanford's office, and he said, and he must have said it with a straight face, because that's the only way I can figure, I can charge you $595 to do this planning, or you can agree to give me 1% of your assets in perpetuity. Now, what client, competent client, would agree to that? That's the sleight of hand with lawyers and who we get fees back. That's the reason we don't have referral fee agreements with financial institutions anyway. Those ethics opinions have been around. They're designed to protect the public from that type of sleight of hand. Because why would you ever pay somebody 1% of your wealth to do your estate planning? Because if this honorable court rules that that's okay, then maybe I need to change my business model or just quit the profession. I just need to find something else to do. Someplace where I really can get 1% of somebody's wealth forever. But I don't think it's appropriate as practicing attorneys. Coming back here to the issue at hand, I do believe there's plenty this court should affirm. I would ask that the court take one step further and that the court would reference this referral fee agreement situation in its opinion to indicate that this type of business behavior is wrong and forbidden for attorneys, and that this type of action should not be appropriate like the standard business model that Mr. Lanford thinks is so appropriate. Thank you.
All right, thank you.
Just
a
a
little over 7 minutes, Mr. Wilkins.
Just a brief rebuttal, Your Honor. He keeps saying he's getting 1% of your wealth into perpetuity. There is no such agreement. The business model involves what Mr. Lanford does with his estate planning clients. It has nothing to do with what he does as trustee, what he does as the charitable trustee of that foundation. They talk about the fact that there was no named beneficiaries. Rarely, look at the MacArthur Foundation that you see advertised on public radio. Do you think they list their beneficiaries in their document? They don't. They just outline what the purposes of the trust are to be for charitable purposes. And as long as it meets the 501c3 muster, it's rare that you're going to see named beneficiaries in a charitable trust of this type. So once again, there is no fee agreement with the Kirk Foundation. There never has been, there never would have been, because that's not the business model he's referring to. They're trying to conflate all of these things together. With respect to the homestead petition, as Your Honor knows, you got to wait till the creditor's claim period runs before you can even file those homestead petitions. In fact, this personal representative never filed a petition they were taking possession of the homestead. And their objection to the claim that Mr. Lanford filed, he paid the insurance, he paid the yard maintenance, he paid the utilities, and they've denied, this was after Ms. Dillard died, but before the estate was open, they denied that he's entitled to be reimbursed for those things. What is he the charity? Is he supposed to be giving his money away? He was taking responsibility for that house. And yes, he waited too long to file that will, but that doesn't have anything to do with his appointment as trustee. They're two different roles. They're two different things. And if the argument is that he didn't file an acceptance, his client has never filed an acceptance, ever. So those are all red herring arguments. If you look at the timing, Mr. Lanford did everything that he needed to do. It was only when they decided they wanted to sell the house, which was a homestead property, that we filed our petition to remove.
You said that the two roles as personal representative and trustee are not related. But you'd agree, for instance, if he had taken 10 years to administer the will, his role as trustee wouldn't start for 10 years.
Sure.
Yeah.
I mean, until you
so
have
they're
assets,
related to that extent.
Until you have assets, you don't have anything to administer.
But he's the one that had the duty to take steps so that the trust did get funded. So they are related to that extent.
Well, yes, they would be related to that extent. But here, that's not a grounds for denial of administration of the trust, removal of the trustee. What we're talking about here is something that's somewhat sacrosanct. Ms. Dillard, and there's no question about her capacity, there's never been any argument about her capacity.
Let me ask you this. If he took 10 years to do it, and as a result the trust wasn't funded for 10 years, would it be reasonable for a trial judge to say, I'm not going to appoint you as trustee, it's been 10 years?
Because you're the trustee or because you're the personal representative?
Because you're both. I mean, you were the personal representative, and you were named personal representative, you were named trustee. You took 10 years to file the will. As a result, the beneficiary had no access as beneficiary of the trust. Would it be unreasonable for a judge to say, look, you didn't do anything for 10 years. Why would I appoint you as either personal representative or trustee?
Well, again, that's an absurd hypothetical, but
Well, at
presumably,
least the next question is, when do you draw the line? Okay, if 10 years, it's certainly appropriate. How about 9 years? How about 5 years? How about 7 months?
how about 7 months? I don't think that's unreasonable. Estates are, in fact,
Oh, the statute says 10 days. I mean,
10
7
days for
years.
filing.
I mean,
Not
7
to-
months is a lot more than 10 days. Would you agree?
not to open probate. There is no requirement
Right.
that you open probate within 10 days.
You're
You
not
simply
going to
file
open
the will.
probate if there's no will. I mean, if the will's not filed.
Correct. But in that same deposition, you will see, and he talked about the fact that this deposition was taken 4 months after Ms. Dillard died. He knew there was a will. Now, why Mr. Lanford didn't file it at that 4-month period, I have no clue. He should have, but they knew there was a will. They knew there was a valid will. It was testified during the deposition, but instead of that, instead of filing a petition to make him produce the will, they filed an intestate petition. Again, that's fraudulent because they knew there was a will. Again, Mary Dillard appointed Scott Lanford. She had a reason for doing that. What we're doing today is if we affirm this decision, you're denying Mary Dillard's constitutional rights to dictate how her money is to be distributed and managed. If, in fact, there was delay, then say it. That's not the basis of the disqualification or the removal of Mr. Lanford. It says there's a conflict. What is the conflict? That's not a conflict. And to basically try to say that we're going to read into that the fact that there's been dilatoriness on the part of Mr. Lanford, there was no dilatoriness on his behalf as trustee. As soon as the creditor's claim period expired, they filed their petition, we filed our petition. That's when they're supposed to be filed. And until he becomes trustee and receives assets, there's nothing to manage. There's nothing to manage. So again, what we're trying to do is use his dilatoriness for filing the will as a grounds to remove him as personal or trustee. That is not a statutory basis for removal.
What's your response to Mr. Krasny's suggestion that any opinion, opine that this type of business model is unacceptable?
Well, first of all, the ethics opinion says it's okay. So if this court wants to...
Well, assuming that the fee is reasonable and that there's full disclosure.
Correct.
I have concerns about both of those issues.
Well, that's a different question, again, because that's not this case. This is the Dillard case.
But you agree with me that the ethics opinion is premised upon full disclosure by the lawyer.
Yes.
And a reasonable fee.
Yes. Well, the reasonable fee is agreed to by the client. It's disclosed. They've agreed to it.
The fact that they agreed to it doesn't equate to it being reasonable.
Well, a lawyer is, if they're getting a referral fee, the question here is whether or not the fee that the broker is charging is unreasonable, it seems to me. Because he gets a piece of that fee, the question is the broker's fee unreasonable? Well, you'd need to take that up with, I guess, the folks that regulate brokers, because I'm not sure that fee is patently unreasonable. And again, the issue here, and I see my time's up, but just let me make the point. The issue here is not that the fee is unreasonable. The issue here is that fee agreement has nothing to do with his service as trustee of this testamentary trust. He is appointed, he did what he needed to do, and all of those ancillary issues really have nothing to do with his appointment in this case. Thank you, Your Honor.
All right, thank you both. Okay.